I am Irene S. Satas from 4G1BS Criminology. So I will discuss what I learned in subject of criminal procedures. First, trial. Trial. The examination before a competent tribunal of the facts put in issue for the purpose of determining such issues. So it is a formal examinations of evidence before a judge, and typically before a jury in order to decide guilt in a case of criminal or civil proceedings. So after a plea of not guilty is entered, the accused shall have at least 15 days to prepare for trial. The trial shall commence within 30 days from receipt of the pre-trial order. So, period of rendition of judgment. Trial courts must give their judgment within 90 days counted from the time of submission of the cases of cases for decision or resolutions. Remedy where accused is not brought to trial within the time limit. So if the accused is not brought to trial within the time limit, the information may be dismissed on motion of the accused on the ground of denial of the dismiss on motion of the accused on the ground of denial of his right or speedy trial. So failure of failure of the accused to move or dismissal prior to trial shall constitute constitute a waiver of that right to dismiss under this section. So absent witness and unavailable witness. So what is the witness? What is the absent witness? Mm. A witness is absent when his whereabouts are unknown or his whereabouts cannot be determined by due diligence. Next is unavailable witness. A witness is unavailable whenever his whereabouts are known but his presence for trial cannot be obtained by due diligence. Reopening of case. If police or the courts reopen a legal case, they investigate it again because it has never been solved or because there was something wrong in the way it was investigated before. So when a case be reopened, a case be reopened at any time before the finality of judgment or conviction, the judge may reopen the case either on his own volition or upon motion, with hearing on either case in order to avoid miscarriage of justice. The proceedings should be terminated within 30 days from the under granting the reopening of the case. So, judgment. Judgment is the adjudication by the court that the accused is guilty or not guilty of the offense, charge, and the imposition on him of the proper penalty and civil liability. If any, it must be written in the official language personally and directly prepared by the judge and signed by him and shall contain clearly and distinctly of statement. So the facts and law upon which it is based. So, uh, contents of judgment. In case in case the judgment is of acquittal, it shall state wherever the evidence of the prosecution absolutely failed to prove the guilt of the accused, or merely failed to prove his guilty beyond reasonable doubt. So, failure effect of failure to object to duplicitous information. When two or more offenses are charged in a single complaint or information, but the accused fails to object to it before trial, the court may convict him of an may convict him of as many offenses as a charge and prove, and impose on him the penalty for each offense, setting out separately the findings of facts and law in each offense. Entry of judgment. Entry of judgment. After a judgment has become a final, it shall be entered in accordance with Rule 36. In new trial or reconsideration, at any time before a judgment of conviction becomes final, the court may on motion of the accused, or at its own instant but with the consent of the accused, grant a new trial or reconsideration. So, what is the new trial? One whereby the accused on his own motion or at the initiative of the court but with the consent of the accused is allowed to present additional evidence in support of his defense or after a judgment of convicted is already been rendered but before a judgment before a final. Motion of reconsideration defined. One filed by the accused whereby he seeks the modification of the conclusion of the court in the judgment of conviction on the basis of what is already on the record. So, in errors of law, a mistake by the court as to interpretation or application of the law. Errors of the fact. Errors in the appreciation of facts, such as when the decision is contrary to the evidence. Next is appeal. Appeal defined a proceeding for a review by which the whole case is transferred to a higher court for final determination. It must be filed within 15 days from promulgation of judgment or from notice of that final order appealed from. So, when appeal must be taken, an appeal must be taken within 15 days from promulgation of the judgment or from notice of the final order appealed from Rule 122, Section 6. So, this period of perfecting an appeal shall be suspended from the time a motion of new trial or reconsideration is filed until notice filed until notice of the order overruling. The motion has been served upon the accused or his counsel or his counsel, at which time the balance of the period begins to run. So, if personal service of the copy of the notice appeal cannot be made upon the adverse party or his counsel, service may be done by registered mail or substitute service. So, what is registered mail and substitute service? Registered mail is done by depositing letter in post office in sealed envelope with registry return card. Second is, so what is substitute service? It is done if the opposing counsel and parties' address are not known, then file the letter or pleading to the clerk of court. That is substitute service. Waiver of notice. So the appeal may waive his right to notice that an appeal has been taken. The appellate court may, in its discretion, entertain an appeal, notwithstanding failure to give such notice with the interest of justice or require. Appellant and appeal. In all criminal cases, appeal to the Court of Appeals. In all criminal cases, appeal to the Court of Appeals. And the party appealing the case shall be called the appellant, and the adverse party, which is the appeal. But the title of the case shall remain as it was in the court of the origin. Next is, ano ba ito? Nalimutan. Next is search warrant. A search warrant is an order in writing issued in the name of the people of the Philippines, signed by the judge and directed to a peace officer, commanding him to search for personal property described therein and bring it before the court. Next is witness in search. No search of a house, room, or any other premises shall be made except in the presence of the lawful occupant thereof, or any member of his family, or in the absence of the latter. So, 2 witnesses of sufficient age and discretion residing in the same locality. Time of search. The warrant must be direct that it be served in the daytime, unless the affidavit assert that the property is on the person or in the place ordered to be searched, in which case is direction may be inserted that it be served at any time of the day or night. So, the validity of search warrant. A search warrant shall be valid for 10 days from its date. Thereafter, it shall be void. Next is proof of the poisonous tree, a doctrine which says that an unlawful search taints not only the evidence obtained thereat, but also fact discovered by reason of said unlawful search. Next is Miranda Doctrine. A rule announced by the U.S. Supreme Court, Miranda versus Arizona, and adopted by Philippine legal system, which requires an officer to inform the person arrested of his rights under the Constitution. Right to counsel. The Miranda rights to counsel is composed of 3 elements. the right to consult with an attorney before questioning, the right to have an attorney present during questioning, and the right to have an attorney appointed if the suspect cannot afford. Next is subpoena, a process directed to a person requiring him to attend and to testify a certain hearing or proceeding. It may be subpoena and testificandum or subpoena juices tecum. So, bench and bar. First, what is bar? It is refers to the legal profession or all lawyers. Next is bench. What is bench? It is refers only to judges and justice. That's all. Thank you.